reconciliation, collective bargaining, and adjudication. At the end of this lesson, you will be able to list the context in which industrial disputes occur, to explain the technique of conciliation, to describe the technique of collective bargaining, to elucidate the technique of adjudication, to look into the advantages of arbitration, to stress the need for developing alternative dispute resolution. Today, we are going to discuss about reconciliation, collective bargaining, and adjudication in industrial relations. All the three are techniques for solving disputes in industrial relations between management and labor. As we all know, sometimes the expectations of management and labor regarding various issues do not match and industrial relations break down. In the worst case scenario, there is a shutdown or strike and production is stopped. A strike is a very powerful weapon used by trade unions and other labor associations to get their demands accepted. It generally involves quitting of work by a group of workers for the purpose of bringing the pressure on their employer so that their demands get accepted. When workers collectively cease to work in a particular industry, they are said to be on strike. Strikes can occur because of the following reasons: dissatisfaction with the company policy, salary and incentive problems, increment not up to the mark, wrongful discharge or dismissal of workmen, withdrawal of any concession or privilege, hours of work and rest intervals. It could be something like leaves with wages and holidays, bonus, profit sharing, provident fund and gratuity, retrenchment of workmen and closure of establishment. Also, dispute connected with minimum wages could lead to such strikes. Reconciliation, collective bargaining, and adjudication are all techniques used in resolving disputes so that there is no shutdown or lockout. Students, we will now look at the three techniques one by one. Reconciliation. In reconciliation, a third party provides assistance with a view to help the parties to reach an agreement. The conciliator brings the rival parties together, discuss with them their differences, and assist them in finding out solution to their problems. Mediator, on the other hand, is more actively involved while assisting the parties to find an amicable settlement. Sometimes he submits his own proposals for settlement of their disputes. Conciliation may be voluntary or compulsory. It is voluntary if the parties are free to make use of the same, while it is compulsory when the parties have to participate irrespective of whether they desire to do so or not. Section 4 of the Act provides for appointment for conciliation officers and Section 5 for constitution of boards of conciliation. The Board of Conciliation is to consist of an independent chairman and 2 or 4 members representing the parties in equal number. While the former is charged with the duty of mediating in and promoting the settlement of industrial disputes, the latter is required to promote the settlement of industrial disputes. The Act generally allows registered trade unions or a substantial number of workers or employees, and also in certain cases individual workmen, to raise disputes. The performance of conciliation machinery, though it does not appear to be unsatisfactory, causes delays due to casual attitude of the parties towards conciliation, defective processes in the selection of personnel, and unsatisfactory pre-job training, and attributed partly to the excessive workload on officers and partly to the procedural defects. Since conciliation officer has no powers of compulsion over labor and management, he can only persuade them to climb down and meet each other. The settlements that are claimed to result from conciliation are increasingly the result of political intervention. Success of conciliation depends upon the appearances and their sincere participation in conciliation proceedings of the parties before the conciliation officers. Non-appearance and non-participation of the parties in conciliation proceedings poses a serious hindrance in this direction. On the attitude of the parties, National Commission on Labour's observed conciliation is looked upon very often by the parties as merely hurdle to be crossed for reaching the next stage. This dampens the spirit of a conciliator. Section 11 of the Act has clothed the conciliation officers with the power to enter premises occupied by any establishment, and also has been invested with the powers of civil court under the Civil Procedure Code 1908 when trying a suit for enforcing the attendance of any person and examining him on oath, compelling the production of documents and material objects, and issuing commission for examination of witness for the purpose of inquiry into any existing or apprehended industrial dispute. These provisions are seldom enforced. Moreover, conciliators most often do not requisite information on the employers and trade unions, up-to-date wage or productivity information, and relevant up-to-date case laws which affect his capability to conciliate effectively. The National Commission on Labour in this context laid emphasis for pre-job and on-the-job training of conciliation officers. Collective bargaining. Students, the next technique we are going to look into is collective bargaining. It is a technique by which dispute as to conditions of employment are resolved amicably by agreement rather than by force. The dispute is settled peacefully and voluntarily, although reluctantly, between labour and management. In the context of present-day egalitarian society with its fast-changing social norms, a concept like collective bargaining is not capable of a precise definition. The content and scope of collective bargaining also varies from country to country. Broadly speaking, collective bargaining is a process of bargaining between employers and the workers, by which they settle the disputes relating to employment or non-employment, terms of employment, or conditions of the labor of the workmen among themselves on the strength of the sanctions available to each side. Occasionally, such bargaining results in an amicable settlement arrived at voluntarily and peacefully between the parties. But quite often, the workers and employers have to apply sanctions by resorting to weapons of strike and lockouts to pressurize one another, and that finally forces each of them to arrive at a settlement in mutual interest. It is thus the respective strength of the parties which determine the issue, rather than the arguments which are largely put on for show as an element of strength in one party is by the same token an element of weakness in another. The final outcome of bargaining may also depend upon the art, skill, and dexterity of displaying the strength by the representatives of one party to the other. Recent trends in collective bargaining. Decentralized and individualized bargaining. The collective bargaining in India remained largely decentralized, that is, company or unit level bargaining rather than industry level bargaining. But in some sectors, the industry level bargaining was dominant. However, privatization of public sector transformed the industry level bargaining to company level bargaining. On the other hand, due to drastic informalization of workforce and downsizing in the industries, the strength and power of the trade unions heavily reduced. The trade unions mainly represented the interests of formal workers. Increasing number of informal workers in the companies soon transformed the structure of the workforce in such a way that the formal workers became a minority. Moreover, in some sectors like garment, there's almost complete informalization of the workforce with only a tiny section of formal workers. It happened in almost all sectors. Due to various reasons, informal workers are not able to form their own trade unions, and on the other hand, they are not represented by the trade unions of the formal workers. These situations resulted in a spurt of individualized bargaining. High level of informalization of workforce combined with individualized bargaining actually changed the character of the trade unions also. In relevant sectors and industrial regions, it converted many trade unions into legal consultants rather than collective bargaining agents. Declining wage share. Declining strength of collective bargaining is also reflected in sharply increasing share of profit and drastically declining the wage share, resulting in depressing purchasing power. Approximately about 73 million out of 173 million wage earners throughout India do not receive minimum wages. About 30 to 40% of these low-paid wage earners belong to poor families. New wave of labor movement for unionization. A new wave of workers' struggle for unionization is emerging from below, by and large independent from the central trade unions. This is mainly emerging in the formal sector. The workers are realizing by their own experiences that they cannot change their fate without organizing themselves in a trade union. In many cases, the workers do not get even the legal benefits like minimum wages, premium rate of overtime, and holidays and casual leaves, etc. Once the union is formed, at least the minimum benefits guaranteed by law are easily available to all the workers. Actually, large numbers of informal workers are illegally put in the category of informal, and they can convert their status into formal workers only by organizing themselves in a trade union. It is in this background that even when the workers are facing unimaginable repression for their attempts to form a union, they are fighting for it. And more workers in new factories are also choosing the same. Adjudication. Adjudication is a private trial-like process that can be commenced by any two or more parties who agree to arbitrate, either under a contract, by legislation, or by simple written agreement. A properly designed, well-managed arbitration process can be completely, quickly, and is a highly efficient means of resolving many types of disputes. The arbitrator is usually an expert in the area of dispute. For example, an accountant for an industrial adjudication plays a conclusive role in the settlement of industrial disputes and in ameliorating the working and living conditions of labor class. In this context, the National Commission of Labour observed the adjudicating machinery has exercised considerable influence on several aspects of conditions of work and labour management relations. Adjudication has been one of the instruments for the improvement of wages and working conditions and for securing allowances for maintaining real wages, bonus, and introducing uniformity in benefits and amenities. It has also helped to avert many work stoppages by providing an acceptable alternative to direct action and to protect and promote the interest of the weaker sections of the working class who were not well organized or were unable to bargain on an equal footing with the employer. The Act empowers the appropriate government to refer industrial disputes when the industrial disputes exist or are apprehended. The Apex Court has also held in Shambhunath versus Bank of Baroda that the power confirmed by Section 10(1) on the government to make reference can be exercised not only when an industrial dispute exists, but when it is also apprehended. Kotwal J. Kashmir Ceramics Limited versus Labour Court. It is not permissible for the labor court to entertain more disputes than are contemplated in the reference, nor is it permissible for it to decline to adjudicate matters which clearly arise in the terms of the reference. Under the Act, an award made by the adjudication authority is final as there is no appeal. However, in actual practice, almost every award made against the employer is challenged in the High Court under Article 226 and 227 and in the Supreme Court under Article 136. It takes year before final orders are passed in writ petitions pending before the High Court or Supreme Court. If the period taken before the adjudicating authority is counted, it does not take less than 10-20 years before the case could be disposed of. It is the weaker sections who are inconvenienced and handicapped the most by the delay. It is submitted that the need of the day is to evolve the framework in which workers and the management perceive the need to cooperate. Bilateral regulation is the most effective method of evolving norms which enjoy wide acceptance. Advantages of arbitration. Well-managed arbitrations can deal efficiently with a vast range of disputes. Small, non-complex disputes can usually be resolved within weeks, while even the largest and most complex disputes should only require a few months to resolve. An attractive proposition compared to the years such disputes take in the courts. Well-managed arbitrations are much cheaper and quicker than conventional litigation. Parties are generally more satisfied with the outcomes as they are more involved in the process and gain a better understanding of what is happening. Confidentiality is another advantage of this process. Both the problem and its solution remain confidential, often a critical factor in sensitive commercial and family business disputes. The usefulness and the advantages of the arbitration and conciliation methods over the justice delivery system through the traditional statutory and constitutional courts are evident from the following table. From the table that you see, we find that the advantages of dispute resolution mechanisms through arbitration and conciliation procedures have more advantageous features with equally effective results than the court system from the point of view of control over the proceedings, binding nature of orders, predictability, and the efficacy in its social relations. Another advantage of the arbitration and conciliation procedure is its confidentiality in respect of trade secrets, family reputations, and other such factors. It has the advantage of transparency between the parties and bringing about a voluntary settlement, compromise, and mutual sacrifice for the purpose of maintaining good social relations. It has also the advantage of choosing one's own arbitrator of choice, fulfilling the mutual agreed criteria laid down by the parties. And the said selection of the arbitrators can be either through the procedure of a voluntary choice or by random method drawn from among the database of number of arbitrators panels maintained by the institution. This will reduce the complaints of bias, impartiality or impropriety and will enhance the confidence of the parties in the decision-making process. The parties also have the choice over the technology to be used in the arbitration process for preserving the records by use of electronic and other traditional means. Alternative dispute resolution. Dispute resolution is an essential component of human civilization. The state is the ultimate arbitrator of any dispute between the parties. However, several alternative dispute resolutions have grown up over the period. In India, the village panchayats have acted as one of the dispute resolution mechanisms. The disputants were given the choice to choose their own elders, either one or two or more, depending on the agreement between the parties, and each arbitrator chosen by the parties to find amicable settlement without jeopardizing the legitimate rights of the party on behalf of whom he is acting as an arbitrator. It is also not uncommon that the elders chosen by both the parties choose another person to head the panchayats. This traditional mechanism is still available in our villages throughout the country and exercises considerable influence in many social and other questions. Side by side, we have the same courts, the state courts sanctioned under the authority of legislative enactments, including the constitutional courts. These courts have a fixed place with a set of procedures already laid down in the form of acts and rules and the mechanism of providing appeals, revision, review of the judgments of the courts either by the same or by the superior courts. The decision rendered by the courts by following the set of procedures is binding on the parties and the same can be executed. The contrast between the state courts and the traditional village panchayats is obvious. One is fixed by the law and the other is fixed by the agreement between the parties. The practice of arbitration and conciliation provides mechanism that is similar to the practices in our traditional village system. However, given the sanction of law, the Arbitration and Conciliation Act of 1996 is going more approximate to the traditional system, giving more liberty to the parties to choose their own procedures and arbitrators. This act was passed by the Parliament to consolidate and amend the law relating to domestic arbitration, international commercial arbitration, and enforcement of foreign arbitral awards. Further, it also defines the law relating to conciliation process. Now, the people are more interested in looking forward to develop alternative dispute resolution mechanisms subject to the law laid down under the Arbitration and Conciliation Act of 1996, which will provide an effective mechanism for minimizing the overall time and cost of a person while maximizing the time available at one's disposal to be utilized in a more productive manner and thereby maximizing one's utility and profit while maintaining good relations, even among the disputant parties. It would also promote honesty, truthfulness, transparency, and morality in social life. The need of searching for such type of alternative dispute resolution has become more urgent to our people in view of the opening of the floodgates of our borders to the global competition and any laxity in finding ways and means in reducing the wasteful time and expenditure in unproductive and time-consuming litigation in the courts will be only contributing to our incompetence in the sense that our cost price of any product or service will not be matching to the international or global price structures, and our maneuverability, that is planned evolution of price suited to the market environment, will be at a stake. Hence, we have fine-tuned the existing alternative dispute resolution mechanisms so as to provide better channels to the people to resolve their disputes without resorting to the traditional court justice delivery systems, and therefore utilize the opportunities to establish arbitration institutions as contemplated under the Arbitration and Conciliation Act of 1996. Let us look into an observation made by a jurist on the subject. No doubt, the state intervention in the form of compulsory adjudication has significantly contributed to the settlement of all sorts of industrial disputes between industrial employers and their employees. But its very success is the failure of the collective bargaining process as the normal method of settling industrial disputes. It follows that if collective bargaining has to gain ground, the state intervention through compulsory adjudication must wane to the vanishing point. It has outlived its utility. It is far better to leave the management and trade unions to settle their differences and disputes among themselves than referring to the issue to a third-party settlement. Any attempt to solve socio-economic problems arising out of industrial relations within the old framework may have some limited usefulness, but cannot, in the nature of the case, achieve any adequate solution. The frequent breakdown in industrial relations must give way to constructive programs. In other words, of Professor Matthews, the state intervention through compulsory adjudication has often been directed to the peripheral area of legal pathology rather than to the healthy core of practical working cooperation. The settlement of disputes reached by mutual discussion, debate, and negotiation leaves no rancor behind and helps to create an atmosphere of harmony and cooperation.